Okay, let's get going. Well, good afternoon, everyone, and welcome. And thank you all so much for joining us today. Do a couple of introductions. For those of you that don't know me, my name is Avril Craig, and I'm the Payroll Director here at Henderson Logie. And I'm joined today by my colleague, Roz Tippett. She's from Henderson Logie's People team.
Hi everyone.
So, what we're looking at today. This webinar aims to deliver insight on the upcoming changes that will be implemented due to the Employment Rights Act 2025. It's not so much a technical update, rather it's a heads up, because there are important changes that all business owners need to know about. Our aim is to give information to our full audience. Today we're joined by Payroll Bureau clients. We have business owners, we've got clients that look after their own payroll or HR function, and we've got people joining us who aren't clients, but everyone's welcome. We want to spend some time today letting you know what this Act means for you and to let you know what you should be doing in preparation for the changes. We're going to discuss potential impacts of these changes on employers. So, while we applaud any measures that protect workers from unscrupulous employers, today we're coming from the angle of the business owner and really what the changes today mean for business owners. Every single organisation is going to be impacted to varying degrees. So I hope the insight today will assist you in shaping up your own business's plans. As always, we're always happy to help you if you need some help and guidance. I would say we're coming to you from two angles, really. We're looking at the HR perspective and the payroll reporting side of things as well, because both sides need to be considered. Our aim is that you'll leave this webinar today with a good grounding, a good indication of what your organisation needs to do in preparation for these changes. If you've got any questions, pop them in the Q&A box and we'll address them at the end of the webinar. If we don't get through them all, we'll definitely respond to them all by email. You're also welcome to just email any inquiries you've got directly to me or to Roz. We expect this webinar to be about 30 minutes long, and then we'll look at some questions at the end of that. So I'm talking about changes. What are the key changes that are coming in? We're going to look at these in a timeline form. We'll look at the things with the most immediate impact, and then we'll look at some changes that are coming down the line. First and foremost, we're going to look at statutory sick pay and impending changes, because that's going to have a big impact. The next thing after that is I'll look at the Fair Work Agency and I'll tell you what that's about, what it means for employers. From there, we'll look through some of the other HR related changes that are coming in due to this Act. Family leave, unfair dismissal, 0-hour and flexible contracts, dismissal and re-engagement, third-party harassment. There's new measures being brought in covering all these areas, and you need to be familiar with what's coming up. So what we're going to start with is statutory sick pay. And at this point, I'd like to hand you over to Roz. She's going to walk you through the changes that are coming up here. Over to you, Roz.
Thanks, Avril. So, hi everyone. As Avril's outlined, there are a number of employment law changes coming into effect from April 2026 and continuing through to 2027. So these aren't just small tweaks, they're significant changes and they are going to affect how businesses manage sickness, probation, family leave, and that's just to name a few. So what I'm going to focus on is what this means for you in your day-to-day business. As we go through each area, I'll highlight what's changing, what the potential risks to employers are, and what practical steps you could be considering. So statutory sick pay is likely to have the most immediate operational and cost impact for many businesses. There are three key changes that are coming in April. So SSP will become payable from day one of sickness. At the moment, if an employee is off sick, they wouldn't qualify for SSP until the 4th day. Lower paid workers who previously didn't qualify will now be eligible as the lower earnings threshold has been removed, and the SSP rate is increasing from £118.75 to £123.25. So in practice, this means that more employees will qualify for sick pay. It's important to note that if your business provides enhanced company sick pay, the scheme rules will still apply. So an example is if your policy provides 1 month's paid sick leave for employees after 1 year service, an employee with only 6 months service would still only be entitled to SSP until they hit that 1 year mark. So what are the potential risks? So I've listened to a number of HR podcasts and webinars over the past few months about the changes to SSP and the Employment Rights Act. And a key concern is that the removal of the 3-day waiting period, as well as the lower earnings threshold, will result in a rise in short-term absences and potentially higher sickness costs per employee. And this is because the financial barrier has been removed. Employees who may not have called in sick previously may do so as they will receive payment. So whether that happens remains to be seen, but I think it is something to bear in mind. And how can businesses minimise the risk of this happening? So you could be updating your absence policies, your handbooks and internal guidance to reflect all the changes to SSP. Reviewing your absence policies, you could consider adjusting or implementing absence triggers. So for those that don't use them, an absence trigger is something that could be if an employee has a certain number of absences within a specific time period and meetings with the manager or HR is held to discuss the employee's absence record. You could review your absence notification process, think about, is it effective? How do employees call in sick? Do they need to phone in? So these are some of the questions you could think about when you're reviewing your processes. I would be using this as a chance to review how your current system works and ensure that it's clear, consistent and robust, and does it actually work for you? Strengthening your processes now could help you manage any increase in absences more effectively when the changes do take effect. Training your managers to handle absence conversations confidently and getting them used to asking some probing questions about employees' absences. It'd also be ensuring that your management team understands the financial impact. So this is not just an HR issue, it affects budgets and it's going to affect day-to-day operations. So I'm going to pass back to Avril, who will talk you through the payroll implications.
Thanks, Roz. Well, there's definitely a lot there for employers to consider from an absence management point of view, and also getting the policies and the paperwork right. From a payroll angle, there's a few key takeaways for employers to think about. So your payroll processes will need to be adapted to ensure that you record every single day, full day of absence from April onwards, as every single day will attract statutory sick pay. Some of you pay occupational sick pay, so perhaps your employees maybe get 1, 2, 3 months full pay, and you maybe not worry too much about recording the odd day off here and there, but actually has to be done now because SSP, statutory sick pay, and occupational sick pay run concurrently. You can't start statutory sick pay at the end of an occupational sick pay period. So really every single day of absence now needs to be captured and entered into your payroll system. Another thing to remember, that every single employee from day one of their employment is now entitled to statutory sick pay. And that's paid at the lower of 80% of their average pay or the standard statutory sick pay rate that Roz just outlined there. There's no lower earnings threshold either. It used to be that people earning below £123 per week didn't qualify, but they do now. Even if they only earn £70 a week, they're entitled to 80% of that if they go off sick. Now, this could mean that employees that start with you 1 week will go off sick in the second week, and then they're entitled to statutory sick pay for the duration of their absence. And that can go up to 28 weeks, as we know, as long as it's certified. So what Roz was talking about there about absence management policies, getting a really strong handle on that is vital. And I think it's going to impact costs as well. In my mind, the likes of the hospitality industry and care sectors, they tend to have a lot of younger transient employees, maybe only working, short contracted hours. I think these industries will be the hardest hit financially by this measure. So start thinking about your statutory sick pay processes now and your absence management policies. I'd like to move on now to speak about the Fair Work Agency. Again, this is part of the Employment Rights Act. Part of that is the launch of the Fair Work Agency. Now, this begins in April 2026 and it becomes the UK's new single enforcement body for employment rights. This is a topic that employers really need to sit up and pay attention to. The Fair Work Agency are all about ensuring compliance, and let's be honest, we all know how HMRC work. They're all about punishing non-compliance. The Fair Work Agency will have broad enforcement powers, which will roll out over time, and we'll be covering the full aspect of this in future webinars. But right now, the key things to be aware of are national minimum wage compliance, holiday pay accuracy, and statutory payments enforcement. Let's start looking at national minimum wage. For reference, the current adult rate for minimum wage is £12.21, and in April that goes up to £12.71. The problem I see is so many people wrongly think that paying these published rates is enough to ensure compliance, but in reality there is so much more to consider. There's a webinar on our website that tells you all about this in great detail. It's from a year ago, I think, but saying that the lessons there are still valid. So what do you need to do to ensure national minimum wage compliance? Well, first of all, you must know what your employees are categorised as. They might be salaried workers, they might be time workers, they might be output or unmeasured work. Your pay reference period must be correct. For example, you can't pay someone for 5 weeks' work within a 1 month period. It can't be any more than a single calendar month. You need to be able to show the different national minimum wage check calculations for each category of employee. So if you've got 10 salaried workers and 5 hourly paid workers, your check calculations are different for both these categories. And in the check, it's not just how many hours they've worked and what rate they've been paid. We need to look at things like deductions. For example, do you take a Christmas club deduction? That deduction is taken into the minimum wage calculation. So it'll be gross pay less the deduction divided by the hours worked. Does that hourly rate come out to below £12.21 or £12.71 as it will be? Uniform. Do you ask your employees, yeah, I want you to wear black trousers and a white shirt? You're asking them to supply uniform, and the cost of that uniform impacts minimum wage calculation. Do your employees or rather work some hours that they're not paid for? They might, for example, if you start at 9 o'clock and you say to them, I want you in at 8:45 so that you're all ready to, your workstation's fired up and you're ready to go at 9 o'clock. That 15 minutes is working time. If you're in an environment where people use protective clothing, just that 5 minutes at the start of the shift and at the end of the shift, putting on the uniform. If you say to them, I need you on the floor ready to work at 8 o'clock, so that means they have to start getting ready at 5 to 8, that's working time. And that would be brought into any assessment done by a minimum wage inspector. And what about recording all the time work? If someone decides, I need to finish this project, so I'm going to work to 6 o'clock. You're only paying them to 5, but have you recorded that extra hour somewhere? Essentially, what you need to be able to do is demonstrate that you've captured all the hours, all the deductions, all the different variables that impact minimum wage calculation. And you've done that calculation, and you can demonstrate that everybody's paid above. I've not mentioned on here salary sacrifice. That's another thing that impacts minimum wage. So if your people are in a pension salary sacrifice, minimum wage is calculated on the pay after the salary sacrifice deduction. So your calculation could then become quite complex because you've got their basic pay, and then we have to take off of that any Christmas club deductions, salary sacrifice, and then that pay that you're left with, we have to divide that by the hours that they've actually worked, which is their contracted hours plus any unpaid work. So you can see how easy it could. Someone's apparently paid 15, 16, 17 pounds an hour with salary sacrifice, with Christmas club deductions, with a few extra hours here and there. Suddenly that could then become a minimum wage breach situation. So these calculations have to be done in order to check that. One important point I want to make is whoever does your payroll, it might be Henderson Logie, it might be an internal team, it might be another payroll provider. Your payroll team can't guarantee that you're minimum wage compliant. They can check that the core salary divided by the hours worked is above minimum wage, but they don't know if someone's coming in early, going home late. They don't know if you're asking them to provide things for their employment. You know, black trousers, white shirt, all that sort of thing. They don't know all the facts. So if they don't know all the facts, they can't do a full holistic end-to-end check. We're going to contact our payroll clients on this topic, and we're going to help them to shape up a solution if they don't already have one and if they need one. So what I'm urging you to do is to check that you have a good system in place for monitoring national minimum wage compliance. One that you can demonstrate to an inspector if there ever was an inspection. In terms of inspection, we know that the Fair Work Agency will, over time, ask for data, and they'll look at holiday pay, they'll look at statutory sick pay, and they'll look at minimum wage altogether. So it's really important to get everything lined up and a robust system for making sure that everything's compliant. Okay, let's look at holiday pay. Holiday pay enforcement is now a major focus of the Fair Work Agency. I have discussed this in previous webinars, and again, they're on the website for you to have a look at if you want to reference that. It's important to get this right going forward. If you think you aren't doing this right at the moment, I would suggest you get it right going forward, and you think about looking back the previous 2 years to pick up any anomalies, so that if you do that, you know, down the line, when the Fair Work Agency start looking at this, you're going to be in a good position and everything will be spot on. So when I say make sure you get it right, what does getting holiday pay right look like? If your employees work to contracted hours, you say, you know, your contract says 20 hours a week, 35 hours a week, whatever it happens to be, then how you calculate their holiday is by reference to a 52-week average of pay. And that pay has to include overtime, shift premium, anything that's, you know, over and above their normal basic pay, their normal salary. And they have to be, if they're on holiday for a week, they have to be paid an average of all of that, not just their basic pay, an average of all of that. If you employ 0 hours or seasonal employees, the calculations for their holiday pay are different. They're actually a bit simpler. You may be able to use the rolled up holiday pay method, but you know, it's essential that you get the right calculation for the right category of employee. And again, in anticipation of all of this, we're going to be in touch with our Payroll Bureau clients, help them shape up a solution if they don't already have one. And as I mentioned, we've got a webinar on the website if you want to have a look at that and just, refresh your memory on what the requirements are. Last thing for now on the Fair Work Agency is statutory payment enforcement. Now we've just talked, Roz has just talked you through the changes to statutory sick pay. So that clearly means that there's going to be more statutory sick pay being paid out. But statutory payments extends to maternity pay, paternity pay, and all these things, adoption pay. The Fair Work Agency will enforce non-payment or underpayment of statutory payments. Sick pay, holiday pay, minimum wage, paternity pay, they can come in and look at all of these and make sure that they're being done correctly. As mentioned, it will take time for these measures to be fully implemented by the Fair Work Agency, but they will look back. They'll look at what you're doing now and they'll look back a certain period. So what we need to do is prepare. You need to create a comprehensive system to show that you're performing check-in calculations to ensure compliance. As I mentioned, payroll alone can't be relied on for this because whoever does your payroll don't have all the facts. They only know the hours and the salary. There are things they can't see, and there are things that they can't see that have to be factored into the calculation. So work with your payroll people internally, us, another provider, to create something together that's going to help you to monitor that. For minimum wage, the Fair Work Agency can go back as much as 6 years. So that's minimum wage. But for holiday pay, again, ensure you've got a system for picking up those extra payments like overtime and commission and wrapping these up into your holiday pay calculations. We're happy to support you on that. But essentially work with your payroll people to ensure that your system is spot on. On holiday pay, the Fair Work Agency can go back 2 years. So if we get it right now and maybe go back a year or two to correct anything, by the time they come looking, everything will be spot on. And the last one is statutory payments, sickness. Please ensure from the 6th of April you are recording every single day of sickness absence and paying them correctly in payroll. I think it'll take a bit of time to get used to this new, because it's probably data that you didn't always have to share with payroll before, especially if you're on occupational sick pay. You're not going to report the odd day off here and there, but every single day now has to be captured in payroll and statutory sick pay calculated. And if you pay occupational sick pay, it'll be offset against their occupational sick pay, but it has to be captured in real time. Come March, we will be issuing a technical update by newsletter. So we can put you on the mailing list if you're not already on it. You can just log on to the website and have a read of it. There should be a bit more information in there for you. But again, as I mentioned, you're more than welcome to contact us if you want to talk through your own situation. So enough from me. I'm going to hand you back to Roz now, and she's going to talk you through some more upcoming employment law changes from the HR's perspective and give you a timeline on these as well. Okay, Roz, over to you.
Thanks, Avril. So the next area that I was going to talk about is family leave. So from April, currently employees must have 26 weeks continuous service by the 15th week before childbirth to qualify for paternity leave. For parental leave, employees must have 1 year's continuous service. However, under the Employment Rights Act, they will become day one rights. The restriction on taking paternity leave after shared parental leave is also going to be removed. Currently, it's not something employees can do, but from April, that is something that they can do. So it is also important to distinguish between entitlement to pay and entitlement to leave and entitlement to statutory pay. So while leave becomes a day one right, statutory pay will still require the employee to have 26 weeks continuous service by the 15th week before childbirth. And for parental leave, it will remain unpaid. So in simple terms, although employees may be entitled to the time off immediately, they're not necessarily going to be entitled to the pay element. So what employers could be doing is making sure that employees understand the difference between leave entitlement and pay entitlement, as I think that is probably where there's going to be confusion. So by updating your family leave policies to clearly explain the difference between leave and pay and what the entitlement conditions are. Check that your processes, or if you've got an HR system, make sure that it can handle leave requests from new employees or employees who previously weren't eligible to make the requests. And also make sure that your managers understand the rules so that they can advise employees. If you don't have an HR team, your managers are probably the ones who are going to get most of the queries. The next area that there's going to be reform is unfair dismissal. So alongside these changes to family leave entitlements, employers should be aware of significant reforms to the unfair dismissal rights. And I think this is one of the biggest risk areas. So from January 2027, the qualifying period for bringing an unfair dismissal claim will decrease from 2 years to 6 months. So for those of you that are not familiar with that, the qualifying period is the minimum length of continuous service an employee must have before they can bring an unfair dismissal claim against an employer. But it is important to note that if the claim relates to discrimination, then there is no qualifying period. The cap on compensation has also been removed. It's currently a maximum of £118,223 or 52 weeks gross salary, whichever one's lower. And the time limit for bringing an unfair dismissal claim has been increased from 3 months less 1 day to 6 months less 1 day. So what are the risks to employers? So employees will gain protection much sooner. Claims could become far more expensive as there's no cap, and employees have longer to bring a claim after they are dismissed. So this makes early dismissal high risk. These changes apply to dismissals from the 1st of January 2027, but what this means is that employees who started from 1st of July 2026 will already fall into the reduced qualifying period. So notice periods are important. If an employee is in a 6-month probation period and you plan to dismiss them, you need to give them notice before the probation period ends. The statutory minimum notice is 1 week, so failing to give notice by week 23 of employment could push the employee past 6 months service, giving them unfair dismissal protection. So it is something to be careful of. So what employers could be doing is strengthening their probation and early performance management policies and procedures to ensure that issues are identified and dealt with early on. Train managers on capability and disciplinary, but also on having difficult conversations, letting them communicate to employees if they're not meeting the required standards. And review the termination templates and consultation processes, ensuring that they do comply with the new legislation. So moving beyond dismissal rights, the further reforms are happening, and that's concerning 0 hours and flexible contracts. So some of you may be aware, from the 6th of January 2026, workers on 0 hour arrangements cannot be penalised for having another job. So that could include reducing employee shifts because they work elsewhere. Further regulations are expected to be introduced later this year, including a right to guaranteed hours reflecting actual hours worked, a right to reasonable notice of shifts, and compensation where shifts are cancelled or moved at short notice. These changes will significantly reduce flexibility employers have relied on in some sectors, and I was thinking of hospitality when I was researching this, but a lot of sectors do kind of utilise seasonal workers as well, so that could all have an effect. So employers should be reviewing how they schedule shifts, avoid any informal practices that punish workers for outside employment. You could start tracking average hours worked. This will help if guaranteed hours become mandatory, and avoid cancelling or rescheduling shifts at short notice. In addition to changes affecting the flexible working arrangements, employers must also prepare for major restrictions on dismissal and re-engagement practices. Another one coming in October, employees seeking to change contractual terms such as pay or working hours will require employee agreement. Dismissals linked to refusing to agree to contractual changes will be automatically unfair regardless of length of service. So the only exception to this is where the employer can meet a very stringent financial difficulty test. So employers should be reviewing contracts and variation clauses, ensuring that your current employment contracts contain clear lawful variation clauses. I think it's important to understand that even if your contracts have these variation clauses, they could be limited protection. Use early, meaningful consultation to speak to employees about any proposed changes and escalate proposals affecting pay, hours or pensions to your HR or seek legal advice. It is important to note that mistakes in this area are going to be costly. Getting expert advice early on is probably the best way to avoid significant legal and financial risk. Another development coming in October 2026 is the third-party harassment. So in October 2024, employers had to legally take reasonable steps to prevent sexual harassment in the workplace. From October 2026, this duty has been strengthened. Employers must take all reasonable steps to prevent harassment. An employer will be treated as permitting harassment where the employee is acting in the course of their employment and the employer has failed to take all reasonable steps to prevent the harassment. So further guidance is expected on what all reasonable steps will require in practice. However, unfortunately to date, there's been no date given as to when this guidance will be available. The risk is that this does place a proactive duty on employers, so it will not be enough to respond after something happens. You're going to have to demonstrate that you took all reasonable steps to prevent the harassment. So what you could be doing at the moment is start conducting risk assessments for your frontline roles, identify any potential risks and how can you mitigate them, update anti-harassment policies and communicate them to employees. We train your staff and managers about what is harassment, what's acceptable, but also training your managers on how to deal with complaints if they receive any and when to escalate. Implement clear reporting and preventative measures and keep evidence of steps taken as you may need to demonstrate this at a later date. The key shift here is from a reactive response to a demonstrable prevention. Something else to be aware from October 2026 is trade union access. Trade unions can request physical or virtual access for recruitment and representation. So the purpose will be representation, not industrial action. Further guidance is going to be issued on this before October, but it is something else that we should bear in mind. So hopefully you can see that the changes coming through in 2026 and 2027 significantly raise the bar for employers, both in terms of compliance, expectations and the potential cost of getting things wrong. They signal a clear move towards greater accountability, transparency and a much more proactive approach to managing risk. I think it's safe to say that there are interesting times ahead, but an opportunity to tighten up on current processes and build credibility and trust within your workforce. So I'm going to pass you back to Avril for her final comments.
Thanks, Roz. Okay, so it's only been just over 30 minutes and we've covered a lot. I do appreciate that, and I appreciate there's a lot to sort of think about and you need time to let everything sink in. I would encourage you to do, there's lots of information out there. There's various blogs and vlogs and there's other webinars too. So I'd encourage you to have a look around and gather as much information as you can on this. I think the key message is start preparing now. These reforms are a great shift towards greater worker protection, which is brilliant, but stronger enforcement, which isn't so good for employers, and actually more accountability for employers. And I think the organisations that will do well and thrive are those that start planning early, invest in compliance, put some time into getting all this looked at and lined up for your organisation. Good open communication and training and empowering your managers. Roz has touched on a lot of this. Just build fair, transparent workplaces. any adjustments you can make now will prevent major risks later on, and that will build a good trust and stable environment in your workplace. We are going to continue to communicate on this topic, and as always, we're here if you need to discuss your own situation at any point. Okay, so any questions? I'm delighted to see we've got quite a few questions coming in. So I'm going to start tackling some of them. So when does an employee become eligible for statutory sick pay, and how long can it be paid? So day one, if they're eligible from day one of employment. Now, if they start with you on Monday and they go off sick on Tuesday, actually they're not going to be entitled to any money because, you know, they've not earned any money, or they'll get 80% of their first day's pay. That's how much they're entitled to. But they become eligible on day one, and it can be paid for up to 28 weeks, as long as it's certified with, you know, medical certificates. Someone's asked me if the slides on this webinar will be sent out afterwards. Yes, you'll get a recording, so obviously that'll cover the slides as well. And it'll be available on the website as well. On minimum wage, if we require employees to wear black trousers as part of the dress code, would this be classed as a uniform requirement and therefore have implications for national minimum wage? Yeah, actually. If you're saying to them, I want you to wear black trousers, that example said earlier, white shirt, you know, they have to supply this, they have to go out and get this, and the cost of that in the week that they, or the month that they've incurred that cost, should be brought into the calculation for minimum wage. On that, you know, you might think, well, they might already have black trousers, so they could just turn up in them. What you've got to remember is, should you have a situation where a minimum wage inspector comes along, and I have to say, in the last year, I've had more minimum wage inquiries than I've had in the last 10 years. So it's fair to say that, you know, interest in this is ramping up. I just think that if your policies say, you know, let us know how much you paid for your uniform, but do, maybe it's not a uniform, but it's a dress code. And if you're requiring them to spend money on something in order to do their job, it should be brought in. It's just getting everything documented. Minimum wage inspectors can come in and interview your workforce, and they could say, so are you told to wear these? And if they say, yeah, you know, that's that information captured, and it should be part of the checks. It might just be that the cost of it isn't significant enough to make an impact on minimum wage, but if your employees are paid at that threshold, it certainly could. I'm also being asked if the Fair Work Agency can go back 6 years, but you only need to keep 3 years payroll records. How does that work? Yeah, it is a bit of an anomaly. Best practice is to keep 6 years plus your current year payroll records. That's, you know, because then you can go back and you can prove. The legislation does say that you only need to keep detailed wages records for 3 years, but maybe then we can say that it's just your minimum wage records for the earlier 3 years that you need to keep. You just need a defence file. You just need evidence. You just need to be able to say, look, I'm compliant, look at my records. That's what you're looking for. Both certificates, sorry, Roz.
I was going to say that one, but I'll let you go.
You jump in. I've said enough today. Everybody's probably sick of hearing me.
Asking about, will self-certification days still be the same as just now? As far as we know, yes, there's been no kind of communication to say that's going to change. So for those that, if you're off basically seven calendar days, anything over that, you'll need a footnote. So I would still go with that.
Brilliant. Oh, look, thanks everybody for all these questions. You can see Roz and my email address there. If anything comes to mind, just drop us an email and we'll see what we can do to help you. As I say, go off and do your own research and just get yourself prepared for what's coming up. Right, well, that's us. Thank you so much for joining us today. I know I'm not exactly spreading joy and happiness around this room, but you know, forewarned, forearmed is forewarned, as they say, and hope we can help you to get on the way to making plans to keep yourselves compliant. Thank you very much for your time today, and I hope to speak to you all again soon. Thank you.
Thank you. Bye.
Bye.